morning. How's everybody this morning?
Okay.
Yeah. Close this blind. It's a little bright. Sun finally came out. All right, so we are continuing our saga through the contract, deep in the contract, right? I mean, I was thinking about this morning. I was driving in, and this is session number 5, and we still aren't through the main contract yet. We still have to get to all the exhibits and things. Special stipulations, the whole everything. But you know, as I was thinking about it, even if we end up at 10 or 12 sessions total, which is a lot, you could watch this whole thing and really understand the contract, hopefully. So I mean, that's our
Brilliant. Brilliant idea.
Our goal is to make sure that you really understand the contract so that you can represent your client. Okay, so as last time we ended at the end of 12 talking with the time limit of the offer, right? And we had a long conversation at the end of last time about the time limit and how that worked and all that. So we'll go forward from there. So moving into section C, other terms and conditions. All right. Notices is the first section under other terms and conditions. Notices must be in writing. So if I make a verbal offer to you and you verbally accept it, does that mean anything? Not at all.
As good as the paper's
okay. When would you want to do a verbal negotiation?
If you think there's another bid coming in, so that you can let them know, we're presenting an offer, this is what it's going to be.
Giving them a heads up more than a negotiation. But what about an actual negotiation where you're going back and forth verbally, maybe via email, which doesn't really count for much, right? Because email's really not any different than discussion, right?
Mm-hmm.
Right?
Mm-hmm.
Okay, just checking. So maybe you're going back and forth and you're saying, well, my client would go up to this. Would you, if you can do this, well, you just kind of go back and forth, and then you reach an agreement, and then you put it on paper. Does that work?
Yes.
You can. What's the issues with that? Why wouldn't you want to do that?
No paper trail.
There's no paper trail. Why else?
Sometimes your client may just forget that they said that something was okay.
Well, and not just your client, but everybody involved seems to not always remember. They have selective amnesia as to what they agreed upon,
And
right?
also, your client's not the one actively negotiating with the agent, that other agent, it's you. So if you have an ongoing dialogue, things change throughout the dialogue, and unless your client is sitting right there with you, then you have the risk of saying things or agreeing to things that your client might not want to agree to.
That would be bad, yes.
Yep.
But you could be in communication with your client, prior to any kind of back and forth. So you could possibly get around that. But as you said, the conversation's happening live right there. They're not there. Who knows what you're actually going to say, agree to.
Yeah, but no one's signing anything until.
And the reality is nobody's signing anything, so it doesn't really matter. If you think you got to an agreement, you put it all on paper, you send it to your client to sign, and they're like, no, I'm not doing that. Oh, well, my bad. I misunderstood what you meant, obviously. Okay? Which would be bad, right? That would make you look like you didn't know what you're doing.
Yeah.
So to some extent, that could be, there's a lot of pitfalls. Now, there's one situation where, or a couple situations, where a verbal negotiation is almost a requirement.
Long distance.
No, because you can do e-sign and all that, right? What if you're buying a property from bank or Fannie Mae or a corporate owner, some kind of relocation, where the seller is not really intimately involved with the property. They don't really know. They're not here necessarily. Corporate owner, it might actually be the seller you're talking to is not actually the seller because they're going to sell it to their company, and then the company's going to sell it to you, so they're not actually going to sign anything. In that situation, is a verbal negotiation make more sense? Well, I can tell you with some of them, it may not necessarily make more sense, but with some of them, it's all you're going to get. You know, when you're negotiating with Fannie Mae or some of the banks, a lot of times all you're getting is a verbal or email response that, okay, this is what they've come back with. No, that's not in writing. They haven't signed anything. There's nothing for you to sign. But that's the negotiation. That's the way it works. The biggest pitfall to doing that in a more typical sale or any sale is that you may reach verbal agreement. Say it takes us a day and a half to reach verbal agreement. We get verbal agreement. Okay, let's write it up and sign it. Now another offer comes in. What just happened to your agreement?
Bye-bye.
It's
Doesn't
probably-
mean it.
it at best is at risk. At worst, it's gone. Okay? So that's where having things that people can sign, it may take more work and people complain about, oh, well, I gotta fill out it's a counteroffer form. We're gonna talk about it. It's super easy. Let's just, do it right. Okay, I'll find the mouse here. All right, next one, B, delivery of notice. This one's pretty important, okay? Delivery of notice. Subject to limitations and conditions set forth herein, notices may only be delivered in person, by an overnight delivery service prepaid, so you can't send stuff COD, by facsimile transmission, by registered or certified U.S. mail prepaid return receipt request, or by email. So you can send notices any one of those ways. Is there a way that they didn't mention?
Yeah, with the phone.
Yeah, there's no phone. There's no text. So text is great. It's a great communication tool. It is not an official delivery of notice. You can't text the other agent and say, we terminate. Right?
I thought email didn't count for anything.
Well, email counts as a delivery of notice, but we're about to talk about when it's received, which is where email gets to be an issue. So
they don't consider text an email.
no, text not email.
Well, it's an electronic mail system.
Not technically.
It's different.
It's SMS.
It's more of a phone call type thing than an email type thing.
So, question.
Facebook posts, those sorts of things don't count.
So, if I, this happened, I just want to make sure this is appropriate. So, I sent an offer to my client, they signed it. Then, I sent the signed document through email as an attachment to the other agent. That's okay?
That works, yes, because that's considered delivery. Now, we're going to talk about in a section when that might not work,
Okay.
but generally speaking, that works.
Okay.
Okay? And just as a general rule, we don't like, I heard you say almost opposing.
Yes,
We
I know.
like to
I said
say
it myself.
cooperating. But that's good. Okay, so more importantly is when is notice received? Because we've talked a lot about, there's deadlines and things, right? End of due diligence, finance contingencies, all those different things. When notice is received is incredibly important, okay? You need to make sure that you understand this section, and you need to make sure that all of your clients understand this section. Because if they think that they can sign something at 11:59 and that counts, they're mistaken. Because it has to be delivered prior to a deadline, not just signed prior to a deadline. And not only does it have to be delivered, it has to be received. So remember we talked about due diligence? Due diligence ends at 11:59 p.m., right? Midnight. So if they sign it at 11:58 and get it to you, and it's now 11:59, what are the chances that you're going to get it received by the other party?
0.
Probably 0, unless you're really, really quick with the facts. Like speed faxer, okay? But let's talk about it. A notice shall not be deemed to be given, delivered, or received until it is actually received by the party to whom the notice was intended or that person's authorized agent. So in other words, we can send it to the broker even though it's intended really ultimately for the client on the other side. Okay, so the essence of that is until they actually are aware of it, it's kind of like the acceptance versus binding conversation we ended with last time, right? It's not fair for us to terminate something and them not know it, right?
Right.
We can't just sign it and have it signed effective, 11:30 p.m. and then give it to them 2 days later. That would be wrong, right? Well, it's no different than giving it to them 30 minutes later or 31 minutes later. Okay? And so that's where we look at that. Now, notwithstanding the above, a notice sent by fax shall be deemed to be received by the party to whom it was sent as of the date and time it is transmitted to either the party or the authorized agent by provided that the sending fax produces a written confirmation showing the date and time, the actual transmission, and the telephone number referenced herein to which the notice should have been sent. We get a little legalese here, so let me translate. In other words, if you fax something and you have a confirmation that the fax went through, you're good. So you can fax something at 11:58, get confirmation that it went through at 11:59, and you're free and clear. It's considered delivered, even though no one on the other end has seen it.
So with our e-fax thing, does it do, I've never used the e-fax. Does it
Does
do
have a confirmation,
confirmation?
yes. You can go into the e-fax and print out a confirmation that says this was sent and delivered at such and such a time. Which is why I strongly, strongly recommend using e-fax. Now, let's go one more step before I go too deep into that. The next sentence says, additionally, if a party sending a notice by email receives an automatic reply indicating that the email has been opened, a read receipt, the email notice shall be deemed to be received at that time. So same sort of thing. Since it's an electronic transmission, if we have confirmation that you've opened it or you've received it, then we're good to go. Now here's the problem with that, because there's a big problem with that. Like, this is the elephant in the room. If you send it at 11:30 at night, even if you send it at 6 o'clock at night, and you don't get any read receipt before midnight, is your contract terminated?
Avoidable.
Not necessarily. If you said that you just made sure that it was delivered.
Avoidable.
Because the email you sent, if you send a terminate, let's use the due diligence termination thing, okay? Because that's the most common situation. You're reaching the end of due diligence. Today is the end of due diligence. At 6 o'clock, you email over a TNR. Okay? You don't receive anything back, no acknowledgement, no nothing, no read receipt, no response back, no nothing from the other party, and midnight comes and goes. Is your contract terminated? Does your client get their earnest money back?
No.
No.
No, because they haven't received.
Because technically, according to the contract, that delivery has not been delivered yet. You have not satisfied this when notice is received paragraph.
Can people try to avoid accepting it? I mean,
Of course. That's
okay.
why I was getting ready to bring it up.
That's okay.
What if they just see it, say,
So, like,
"Man, we're not opening that email."
Or
Then what do you do?
in most email systems, have you noticed that sometimes when you're in your email, it pops up and asks you, so-and-so has requested a read receipt. Would you like to send?
Right, yes.
No.
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 Now what?
Yeah.
So they've seen
You
it,
better fax it.
So
but you
use
have no way of
e-fax.
proving that they've seen it.
And for any termination of anything, use e-fax.
For any deadline, for anything, for any notice of anything, you should use the e-fax, okay? Because the beautiful thing about the e-fax system, because everybody says, we had an agent recently try to strike the fax section out of the contract and say that email was the only valid notice, and we were like, no, because there's no way to track when that happens, okay? So if you use the e-fax, You can upload the document into your eFax. You can fax it to the agent's personal fax number. You can fax it to the broker's fax number, which is legally what you should be doing. You can email it to them through the eFax. And all of that is bundled together as one send, and you have confirmation that the fax went through. That gives you your timeline. You're done. You're protected, your client's protected, everything's good. Okay? Try not to do it at 11:50. Try to do it earlier than that. Just because sometimes, you know, faxes do get delayed and they don't get delivered, and you won't get confirmation until, you know, 5 or 10 minutes later sometimes.
So
Most of the time it's faster than that, but sometimes.
you're saying in addition to e-faxing it to the other agent, e-fax it to the broker's
I
office?
highly recommend that you fax it to their office fax number, because that is the official, because remember, you guys are agents, right?
Mm-hmm.
And who do you represent?
The broker.
The brokers, right? And so by definition, you should be making sure, I mean, in the old days, when you, and if you think of this, and this is the part that always gets me, if you remember pen and paper contracts, if we still operate the same way, we just do it electronically. So if you had to deliver the contract, you would go to the broker's office and deliver the contract.
Right.
So you should be delivering the contract and all notices and everything related to the contract to the broker's office. Now, for convenience sake, can you deliver it to other places as well? Absolutely. But from a legal standpoint, your best protection is to make sure that everything is delivered to the broker's office.
Well, I've said this before and I'll say it again. I'm also an appraiser, as most of you know. And every time you do an appraisal, they always tell you to do it as if you're going to defend it in court.
Yep.
You should do the same with every contract.
And this
Period.
notice delivery
In a
thing
conversation.
is one of the biggest holes you can have in your contract and in your process. And so you want to make sure that you are bulletproof in your delivery. The best way to do that is to use the eFax and deliver it not just to the agent, but to the broker.
Okay, but you rattled off a whole list of people that you could e-fax it all in one shot. Who, could you do that one more time?
Sure, so you can send it to the agent's email address.
Okay.
You can send it to the agent's fax number if they have one, which most do. And then you can also send it, which is the one that protects you, you send it to the office fax number. And where would you get that from if you didn't have it?
It's in the MLS.
It's in the MLS. You click on their name in the listing, and boom, there it is. Or you can search them by name and pull it up as well. Okay? And so that is your best bet to protect yourself in that situation. Notice is sent to the broker. All right. Except in transactions where the broker is practicing designated agency, notice to the broker's employees, or the affiliate licensee of the broker representing parties, blah, 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 is basically notice to the client. So as long as the broker is representing or acting as a customer representative for the client, then sending something to them, you don't have, in other words, you don't have to send it to the seller if you're on the buy side. You don't have to send it to the buyer if you're on the sell side, because you're sending it to their agent, okay, or broker. Notice by fax or email to the broker affiliate licensee. This one goes a little deeper into what I was just saying. Notices by fax or email to a broker or affiliate licensee or broker may only be sent to the email address or fax number, if any, of the broker or the affiliate licensee of the broker set forth on the signature page of the agreement or subsequently provided by the broker. So here's an important one when we get to the signature page. If the little block of the listing broker's information didn't auto-populate and all you wrote was their brokerage name and there's no email address and there's no fax number, you have to now personally deliver everything. Because email is no longer valid and fax is no longer valid.
Because you didn't
Because it's not
specify where you were
Because we
gonna
don't
send
have a specification of where it goes. Okay? So you need to pay very close attention to the signature page and make sure that those email addresses and those fax numbers are populated. Okay, and we're going to look at that in a minute. That's the next page, I think.
Two more
Well, two
pages.
more. Maybe we'll get there today. So that's very important. The address, email, or number for receiving notices to a signatory to this agreement shall only be effective if sent to the fax number, email address, or physical address of the signatory listed on the signature page, or subsequently provided by the signatory or other signatories. Hereto in accordance with provisions herein. In other words, much like notice to the broker, if you have to send notice to the buyer or the seller, if their information is not on here, you have no way of really effectively doing that, okay, from a legal standpoint, which is why those blocks are in there. Now, again, if you represent the client, there's no need necessarily for those blocks to be there because all communication should come through you. But if you have, like, for sale by owner, for instance, that's where that block on the signature page comes in real handy, and we'll look at that here in a few. All right, any questions about notice? Because it's extremely important that you do notice, because here's the thing. If you have a client that thinks they've terminated their contract and you screwed it up because you didn't deliver it properly, who do you think's on the hook for their earnest money? You. Even though contractually it might not be valid, but you know, from an ethical standpoint, they think you did, you did tell them it's terminated, and then it's not. You're responsible for that money. Okay? All right, default. Another important section. These little sections, it's a lot of boilerplate language. There's a lot of important stuff buried in this boilerplate language that you've got to read through and understand and explain to your clients. All right, default. Rights of buyers and seller. Party defaulting on this agreement shall be liable for the default. The non-defaulting party may pursue any lawful remedy against the defaulting party. What's that mean?
Specific performance.
You can sue for specific performance. That means that if the buyer defaults on the contract, walks away, doesn't close, the seller can say, I'm going to sue you and make you buy this property.
And vice versa.
And vice versa. If the seller decides not to show up at closing, the buyer can say, I'm going to sue and make you sell me this property.
Does that happen?
It did, I had one.
It does.
Yep.
It's not common. It doesn't happen a lot.
It was,
And at some point, we'll have some conversation as to why it doesn't happen a lot. I mean, in reality, you know, it just, most people aren't willing to spend the money to pursue that.
it didn't go to court, but they both hired lawyers, and the lawyers basically said, hey, you're gonna do this, or you're gonna go to court, and then you're gonna have to do it plus pay court costs. So,
I mean, if the contract is bulletproof,
not a whole lot you can
going to court is really probably not, as you said, you know, I mean, the lawyers are going to look at it and say, you're not going to win this, you know, like, and most lawyers don't like to go to court and lose, even if they're going to make money. They just, it's just bad form. So they're going to tell their client, look, you pay me this big retainer fee, pay me the chunk of money that I want from you, and oh, by the way, you would lose, so you shouldn't go to court. You know?
It really also has to attest to the fact that there's a meritorious claim.
Right, because you don't just bring something to court just for fun, just because you want to. There has to be a valid reason to go into court and take the court's time. So that's why attorneys don't like to walk into court knowing that they're going to lose, because they would get significantly more issued than just losing. So,
Potentially.
all right. Rights of the broker. In the event, this is an important one for you to know, in the event a party defaults on this agreement, defaulting party shall pay as liquidated damages to every broker involved in this transaction with whom the defaulting party does not have a brokerage engagement agreement in an amount equal to the share of the commission that the broker would have received had the transaction completed. Did you get that? You want to keep reading? Because that was,
No.
it
I got
gets deeper and more legal.
Gypsy.
In other words, if you bring a buyer to somebody's property and you're under contract and the seller decides they don't want to sell and walks away, we as the brokerage can collect money from the seller to pay the commission because we did our job. It wasn't our fault.
Now, if that were to happen, is that something that Coldwell Banker would do, you know, in our legal department?
Yes.
Okay.
Now, here's the reality point to that. If it's $1,000 commission, it's probably not worth chasing. It has to be relatively significant. I'm not going to put a number on that because it depends. It varies. You know, I mean, I've seen different numbers go after. What we most of the time do is try a little bit of legal intimidation that, you know, we don't want to necessarily end up in court because the cost of court pretty much wipes out any commission that we're going to get. But we will engage our attorneys that we have on retainer and send letters and say, you owe us this money, and try. But, you know, it just depends on the amount as to whether it's worth it, time and effort. And you do want to read under your legal defense fund. There's a certain way that that gets paid out, and there's parts of what you have to pay to help go after commission versus what it's not just us, okay? Because obviously any money we collect is then split out. Well, if we bear all the cost and you get the majority of the money, that doesn't work out right. So it's just a balance. Yeah, it sounds good to you, right?
It's a business.
But we do still have to keep the doors open. So sometimes it's really your call as to whether you want to contribute any money towards going after a commission, because it's a business decision at that point. Is it worth it for us? And we'll collectively talk about it. Is it worth it for us to go after or not? All right. Risk of damage to the property. If the property is destroyed or substantially damaged prior to closing, seller shall promptly give notice to the buyer of such claim of the same and provide the buyer with whatever information seller has regarding the availability of insurance and disposition of any insurance claim. Tree falls through the center of the house 3 days before closing. Is the buyer still on the hook to buy the property?
Nope.
Unless the seller can get it fixed 3 days.
Or either side of the insurance check.
But then that's the buyer's choice.
That's what I'm saying. Because, yeah, he's
But,
still
I mean, the buyer's not necessarily, the buyer
You're
can
not
still
obligated
close.
to
It's-
buy.
They're not obligated.
It's avoidable.
Right. Now, if the seller can get it fixed and back to the same condition prior to closing, so maybe the tree falls on the house 3 weeks before closing, and the house is back to substantial difference, does the buyer have to close? Yeah.
Yeah.
Because the house is in the same condition as when they wrote the contract. And that's kind of the key to this paragraph, is the house has to be in the same condition as when they wrote the contract. So if something happens, then the seller's responsible for pulling it together. And there's 14 days, and then there's a 7 days, and you know, you need to read through this and understand that it can be extended, the closing can extend, and you know, obviously if the buyer still wants to buy the property and the seller's doing the right thing, getting it fixed, or wants to sign over insurance, you know, I mean, there's lots of variations that come through this, but the reality is that the obligation on the seller is that the property is in the same condition at closing as it was when they wrote the contract.
What if it's in better condition?
So that's fine.
I mean, no, because I'm just thinking, because I know someone who had a tree fall on their house, and then they I mean, it was an older home, so they lucked out. The insurance ended up giving her like a kitchen with a thermidor, I mean, like top of the line stuff, which before the tree fell, the house was probably like 100,000. Now with this new upgraded thing, it's significantly more. So the seller could not back out. They would have to sell it at that price.
Buyer's choice.
Buyer's choice.
Oh, buyer's choice.
It's the buyer's choice of whether they're going to close.
Well, if you were the seller,
If you're the seller, you wouldn't have
you
that
wouldn't
happen
spend
prior to.
$400,000 on a kitchen. You'd spend 10 and pocket 390.
Well, not that
You can't
much.
do that.
do that. That would be insurance fraud. But you could not necessarily, you know, get everything done prior to closing, which would be where the buyer
Where you
would.
could walk. Okay,
Right.
I gotcha.
But you also, from an insurance standpoint, I mean, the insurance is not required to repair the house to better than previous existing, you know? So, I mean, in that case, the insurance was overstepping and not doing what they were supposed to do, which, you know, so, I mean, there's a lot of variance there. And there's a lot of variance in what, I had a friend around the corner actually who had a tree fall in their house, and the insurance was going to pay, obviously, and they were going to do some renovations. They were going to add some money to that and do some renovations. And it turned out it was cheaper to tear it down and start from new. So literally yesterday,
Tore it
leveled
down.
their house. So, but in that case, you just have to be careful a little bit of how you handle insurance. Obviously, the client's not you, because you don't want to be in a fraud situation. And if you just pocket the money.
Well, and different people have different kinds of insurance.
Correct.
I mean, we had a relative who had reproduction insurance on their house, and when it was damaged, everything was put back as it was on the day they moved in.
Right.
Which was in the 60s,
Well, that's
so
the
that was kind of
Look,
weird.
I got a
but-
question for you then. Let's say you have a garage detached, the tree falls on it, and the insurance company says, they come out and they say, it's worth $10,000, they write you a check for $10,000. You don't have to rebuild the garage.
You don't have to rebuild the garage, but if you were under contract to sell that house,
with
and the garage was there when they wrote the contract, then you're contractually obligated to have that garage there prior to closing, or the buyer can walk.
I agree.
So technically,
But
you
would
don't
you have to spend $10,000?
on that
You would-
garage.
You would have to replace
It would
that
have to
garage.
be-
I
because they
mean,
gave it
hopefully
less.
that $10,000 is close to the cost. Now, if you're the person, you can do it yourself, or you got a brother that's, then you might be able to pull it off cheaper. But in theory, that insurance money is not more than what it would
Well,
cost
I
to
understand that, but
put that back.
if you got it, put it back like it was, cheaper than the check,
As long as
there's
it's
no
the
fraud in
same,
pocketing the difference.
as long as it is the same quality from a contractual
of course.
standpoint.
I mean, you wouldn't
And I'm not
put up
talking insurance
10
fraud, but I'm talking
but yeah.
from a contractual standpoint in real estate, it would have to be the same caliber quality that was there before or better.
Right.
Okay? All right. On to the next one, other provisions. Entire agreement modification and assignment. Anybody know what all that is? So the agreement, this is the entire agreement. In other words, there can't be any other outside agreements between the parties. So when you go to a closing, if you haven't been to one yet, one of the things the attorney asks is, and they sign, usually especially if there's a mortgage, is a document saying there are no other agreements between the parties outside of the contract that we're all aware of. In other words, I didn't agree that I'm going to give you, $50,000 cash after I buy your house, or vice versa, or whatever. I mean, there's weird situations where that's happened, and that's again generally fraud.
Or a lawnmower.
Or yeah, no, things of value. That's the other thing. If you're not disclosing the fact that, oh, by the way, it's fully furnished and all the equipment and everything stays with it. What? You've got to have. Everybody's got to know that kind of stuff, because that plays into the value concept of what's going in. The other thing is the assignment. It can be may not be assigned by the buyer except with written agreement of the seller. So by definition, our residential contracts cannot be assigned unless everybody agrees to it. Now, here's the fun part about assignment. If the buyer is assigning the contract to another buyer or adding another buyer to the contract, which is similar, does the seller need to sign that amendment? Yes, right, because they have to agree to it. What about buyer number one, the original buyer? Do they need to sign that agreement?
Yes.
Yes. Then what about buyer number two that's actually being assigned or added?
Yeah.
Yes. So I've seen some lately where people have added third parties without the third parties signing the document and adding them. And you think to yourself, but wait a minute, how do they even know that they're, we need to know that they're on board for this too. Survival of agreement. The following shall survive the closing of this agreement. The obligation of the party to pay a real estate commission, any warranty of title, and all representations of the seller regarding the property, and any obligations with the parties herein agree shall survive the closing, or may be performed or fulfilled after the closing. So in other words, if you write a stipulation, which we'll talk about later, that a certain repair or upgrade or whatever is going to be done after closing and shall survive closing, then that would survive. Okay? The representations of the seller regarding the property. So just because the property closes and the seller was trying to hide something doesn't mean they're free and clear. Because that representation of the property survives closing. So therefore, if the buyer finds out a month later that, oh, that roof leak, oh yeah, that roof's been leaking for 10 years, and it wasn't disclosed that there was a roof leak, who do you think's on the hook for it?
The
The seller,
If you can
right?
find them.
If you can find them, obviously. I mean, that's the world of lawsuits in general, but the seller's legally on the hook for it. Here's the other thing. What if you as the agent knew that that property had a roof leak?
Well, if they can prove it,
If they can prove that you knew that it was had a roof leak, then you're definitely in trouble too. Governing law and interpretation. In other words, this is here by the laws of Georgia. Time is of the essence. Time is of the essence of this agreement. Love that's one of my favorite things because the title and the words are almost the same. Terminology.
But what does that mean? I mean,
What does
time
that
is of-
mean?
I mean,
Lawyer
It
man.
means that time of the essence means that everything must be completed within a short span of time. And if you go beyond that, then you are violating the terms of the agreement. It means that it has to be done quickly.
In other words, if something would normally take you a day or so to do, and you drag it out for a week, you're not operating within the confines of time is the essence.
okay, so in
Right?
essence,
Okay.
anything you do with this contract, it's like a 24-hour tick-tock.
No, not
Just on
necessarily.
Friday afternoon after business, how you gonna get to the bank by Saturday or Sunday?
Right. No,
You can do it Monday morning.
the conversation is that you need to do it in a timely manner. It needs to be done
You can't drag your feet.
right.
Within
You
one
can't
business
stall, basically.
Okay. Right.
Okay.
It's sort of like if you play tennis and, see somebody kind of like bouncing the ball, start to get their serve, then they start bouncing the ball again to psych out the other side. You can't play games.
Yeah, they'll call
slowly.
that on the tennis court, they're in the pros. Yeah, you'll get penalized for that.
It's the same idea.
Okay.
You just have to operate in a timely, efficient manner,
Mhm.
and you'll be fine.
Or a clock.
Okay? All right, binding agreement date. We have talked extensively about binding agreement date, right?
Yeah.
What is binding agreement date?
At the time when it is confirmed, that it's like the confirmation of the agreement. So it's not, I agree, you agree, okay, we agree. It's like the final confirmation that everybody has agreed.
Correct.
So
It's
it goes back.
acknowledgement that we are under agreement.
And the clock starts.
And the clock starts. All right. And that's why it says in here, and we'll read it because I think it says it well. The binding agreement date in this agreement shall be the date when the party making the last offer or the broker, except in a designated agency transaction, the broker's employees or affiliated licensee of broker representing that party as a client, receives notice that the offer has been accepted.
So as soon as they receive it.
This party shall fill in the binding agreement date below and promptly give notice of this date to the other party. Filling in the binding agreement date shall not be deemed to be a counteroffer, which is very important because any other writing or marking that you do on a contract is considered a counter.
When it says this party, it's totally confusing. Which party are they talking about?
The party that received
The offer?
receives notice that the offer has been accepted. So in other words, I make an offer to you. You accept it and send it back to me. I receive your acceptance, and therefore I am this party and need to promptly send you binding.
I'm only asking that because the offer that we've been talking about, you and I, when I sent that offer, everybody signed on the other side, on the cooperating side, and they filled in the binding agreement date.
One of the most common mistakes, as we said last time, that happens unfortunately very frequently, and the best way to correct that is to then send a binding notification form. There's a separate form that you can then send over and just verify that yes, because
Okay.
more than likely it's the same date.
Yeah, it is. It
I mean,
is.
unless they did it at 11:59.
And he even sent it in the email. He said, I've gone ahead and filled this in because binding agreement date will be today, correct? And
But technically, he's not
He
following the
shouldn't have done
contract.
Yeah.
So
And people, that's the one thing that people don't understand.
okay,
For whatever reason,
and he should have known.
they just can't
It's a shortcut.
grasp that. They think that, oh, if I can put binding on here, then time starts now, and there's no way, they're trying to protect their clients. They're trying to operate, a lot of times it's old school agent because we operate back from the old acceptance days.
That must have been the selling agent. He's a listing agent?
He was a selling agent. I mean,
A listing agent or
he
selling
was a
agent?
listing agent.
How did I know that?
He was a listing
And
agent.
they're just trying to protect themselves.
So just so I'm clear, Brett, so we've decided on the offer, we've done the counter and all of that stuff. Then we send the binding agreement form.
After the party that receives the acceptance
Mhm.
sends the binding form. Because binding, the best way to remember is binding is acknowledgement of receipt of acceptance. That's the simplest non-legal way to say it.
Okay, so when I do my contract, I'm coming into your office. And you're like,
So should I do that now, even though it's been a week, send that binding agreement?
You could. I would have done it that day. That would have been better.
I didn't know.
That's all right.
And so I was
That's all right.
wondering, to cover
Well,
myself.
that doesn't
Should I do
change the
that?
date, it's just showing.
Right, you're
yes,
still
Giving us
that's
the
the
that's
file
the
date.
date.
that that
Yeah.
was the day.
So you're just reminding everyone
You're
that that
just
is correct.
confirming.
And it's just one of those, kind of, let's just make sure everything is done properly, there's no holes. And that would be a hole in the contract if the wrong party bound the contract.
Okay.
All right, duty to cooperate. This is kind of like time is of the essence. Everybody needs to work together to get this to happen. You can't, purposely cause issues, basically. All right. Electronic signatures. This is an important one. For all purposes herein, electronic or fax-only signature shall be deemed the same as an original signature, provided, however, that all parties agree to promptly re-execute a conformed copy of this agreement with original signatures if requested to do so by the buyer's mortgage lender or other party. That's important. If the other agent says they want on a wet signature contract conforming, is that a requirement?
Come on, say.
If the other agent, if the agent from the other side, listing agent, buyer's agent, whichever side you're not on, says, I like to have a conforming copy with all wedding signatures. Do you have to do that? Does your client have to sign it?
No, but what's the harm?
Well, we'll talk about that in a
yeah,
minute.
they do have to sign it.
No, they do not. The only time they have to sign it is if the buyer's mortgage lender requires a copy of the conforming copy of the contract with wet signatures. That's the only time they're required to do it. Now, again, they can do it, but they're not required to do it unless the buyer's mortgage lender.
So when
Okay.
you see in the
But it says-
listing where someone writes in the private remarks, no key signature, they can't really do that, because I've seen that plenty of times.
Well, again, if it's like a Fannie Mae or somebody like that, they kind of control the conversation and the way it works. They also have addendums that pretty much negate most real contracts. So,
So it just depends.
yeah. And you also, anytime somebody says something like that, you have to take into consideration what's the impact on your client.
Mhm.
Is it worth doing to get the property? And how much risk does it sway towards you versus not? And most of the time, it's not that big
Yeah,
a deal.
it's
If it's just a signature on top of an electronic signature, it's different than here's a blank and now sign it, because that could easily be a hustle.
But from one standpoint, this does say a conformed copy. So re-execute a conformed copy. So somewhat by definition, conformed copy is a rewritten one. The issue with conformed copies is that, of course, are you sure that everything's the same
Yeah,
as
he's
it's
got a good
supposed to be?
point, because they could change, they changed one little thing.
And it may be purposeful and it may not be purposeful. It may be a typo. They may have forgotten that, oh, the counteroffer said this, this, and this. Oh, there was a second page of the counteroffer. We didn't change that. Who knows? And so you have to be
Especially
very,
if it's a
I
lot
am
of
personally,
negotiation.
right, if it's been going back and forth, back and forth, back and forth, I personally don't like conform copies. That's why I like e-signatures, because you don't have to do conform copies because it all stays legible. The only reason to do conform copy in my world is if you can't read it.
But that's why I'm saying conforming only means signatures.
But in real estate, conform copies or clean copies, as they're more often referred to, is a fresh copy of the contract that's been typed up to match the final terms.
Right, okay.
And that's where you get into issues.
You got, and a lot of the older agents like to do that I've noticed. Not in this office.
Well, for a while, there was a brokerage in town that if they didn't get a clean copy of the contract, they wouldn't pay their agent.
Yeah.
And that was the only ones that I did back when I was an agent. Because, well, let's just say the only ones I allow my clients to sign, because I would still make them write.
Right.
So,
yeah.
But
So question, where it says the buyer's mortgage lender or the other party? Who's the other party? Like who are we speaking to?
the other party is the other side.
Co-oping agent.
So the co-oping
broker.
client. So if the buyer or the seller themselves requested it, then it'd be fine, but not the agent.
But how would you know that? Because
Well, the agent would have to request it.
Comes through,
No, you're right, and so it's a fine line.
yeah.
But the agent would have to request it on their client's behalf, not for their purposes.
Right.
So like the comment that I made, that the agents used to request it because they needed a clean copy because they wouldn't get, their broker wouldn't pay them otherwise. Well,
That's a breach of a
we know that that's not the client that's driving that.
Right.
And so that's really not viable.
and
But
what do you,
again, you have to evaluate the risk to your client. As long as you read it and make sure that it's perfect and what it's supposed to be, them signing a clean copy doesn't do them any harm.
But you still need to go through it line by line.
that's what I was gonna ask. You put them next to each other, okay.
Yes.
You go with rulers
Yep.
next to each other, line by line, word by word, to make sure it's exact. And it takes hours to do it the right way if you're really being careful.
Well, keeping in mind that you're talking about a typical contract that's written from scratch. In these contracts, as long as there's not the boilerplate, I mean, the first page has blanks on it and the sixth page has blanks on it. Everything in between, unless you see something marked, they're legally not allowed to change any of that. And this paragraph is actually where that says that.
Yeah, but I'm thinking in terms of where there may be
Correct.
addenda to the
Right.
contract.
No, right.
And that's
If
where
it's
it becomes
customized,
Especially if there's more than one.
which is where we as agents would not want to do that. We would want an attorney to look at that. And oftentimes when we have a non-GAR contract that's presented to us as a buyer, we send it to the lawyers for them to review and see, is there anything in here that's kind of a gotcha for our clients? Can you review this and help us understand the language? Because that's not really our job. Our job is to understand this contract and how to fill in the blanks. Anything beyond that requires a legal degree, and we don't do that.
So do we have to pay for that?
No, that's
It's part of our partnership.
That protects the broker, because you understand it's still the broker that's on the hook.
So we provide that attorney for you in order to help you
So that's what our for.
cover. Yeah,
That's what our money goes
that's part of the reason that we have that. All right, so this GAR Forms paragraph basically says that these forms are specifically designed for Georgia Association of Realtors members. You can't use them without, being a member necessarily, and you can't make any changes to them unless it's a visible form itself. So like stipulations, you couldn't go in, and this is where the subversiveness would go in. You couldn't go in and go back to, one of these paragraphs and kind of swap out a sentence in the middle of this paragraph and make it not obvious that there was a change, because that would be a violation of the contract itself.
And it would also be, correct me if I'm wrong, practicing law without a license, because the only person that can write a contract is a lawyer. Is that not correct?
Arguably, an addendum is something to talk about.
Well, but we're not talking about addendums, we're just talking about the contract itself.
Yeah, I'm not a contract itself.
So you're right.
Because you're also breaking the law by practicing law without being a lawyer.
Now, the other thing that it says here is that no party is required to use any GAR form, okay? So if you're paying attention, no party is required to use any GAR form. Will we close on a non-GAR form?
No.
Yes.
Sure.
Not if we can help it.
But a lot
Because
of
that's
them,
what
they
have it
own
vetted by
properties.
council.
But we've had it vetted by council. So the other contract that's available in the system, we don't want to close on because it doesn't protect our client. In fact, it doesn't really protect anybody. It has massive holes in it, according to our attorneys. Not me, I'm not the attorney. According to our attorneys, it has massive holes in it. So if you get an offer on a non-GAR contract and you're the listing agent, how do you counter that offer?
On a
On a
GAR
On a
contract.
full GAR contract. Because there's nothing in any contract that says that you have to use a counter form. You are perfectly within your rights to counter with a complete contract. Now, the interesting thing that you'll notice if you do that is that as you go through and try to fill out the GAR contract off of the other contract, even if you're trying to match every single term, you can't do it. Because there's holes, there's things that aren't answered, there's pieces that you basically have to fill in the blanks. And so any blank that is not addressed by the other contract, you obviously fill in to your client's benefit.
You're basically writing a new contract.
And you're writing a new contract. You're making an offer
On a
at
GAR
this
form.
point, you're making an offer from the seller to the buyer.
Right. Because technically, any counteroffer is a new contract.
Right.
Technically.
Well, except for the counteroffer form
Well, I mean, you're not-
incorporates the offer.
Right.
Right.
Yeah. But it's,
Whereas, so we're
because they can just say, well, we don't like that. They have no obligation to respond.
Right.
To a counter.
and so you can write a complete contract. So we almost made it. We got through that section. So next time we'll cover exhibits and agenda. Let's do this actually. Let's do this real quick. Next time we're going to cover exhibits and agenda, and we're going to actually jump to each one of them and cover them individually. So we're going to skip this section real quick. We're going to skip special stipulation because that's a whole other conversation. But let's do the signature page real quick. Okay? Because we've addressed most of these things, and I think we can pretty much knock this out in the next 45 seconds. All right? We are going to put, obviously, our client's information on here. As I said, if we represent them, there's no reason to put any of their personal information necessarily on this contract because all communication should come through us, correct?
Mm-hmm.
So I would delete that email address out of there because I don't think you should leave that on there. You're going to have your information on here. So it's the brokerage, your name printed, the office code and license number, phone numbers and fax numbers, email addresses, license numbers, and the board that you're a member of.
So with that fax number, we should put our e-fax number, or should we put the brokerage?
So what
fax
I would do
number?
if I were you is I would put both. Because if your fax number is not working, you want them to be able to fax to the other fax number, so put both. This is ours, and then I would just put a slash and yours,
Oh.
okay? Because
And
that
put-
way you give them lots of opportunity to communicate with you.
Okay, and use my phone number where it says phone number.
You can use, yes, your phone number there is fine. Again, you can put the brokerage number slash your number if you want as well. You know, the key is that if you give people every possible way to get a hold of you, there can never be any question that they couldn't get a hold of you. Okay? So if you just put your cell number and your cell phone drops in the ocean, and all they do is keep calling the cell phone number, and there's no way to get through, that's a problem, right? So put the office number too. Give them multiple ways to connect.
How do we know if somebody has sent an e-fax back to the office e-fax or your e-fax, how would we know that it had gone there?
Because the office uses an old school fax machine. And when that machine spits out a piece of paper, she picks it up, she being whoever the receptionist is at the time, because it doesn't matter. They're all trained to do that. If something comes in, they look at it, who's it for, and they call you.
Okay, but if this was happening
But if
in
it
the
happens at
evening,
11:30
then-
at night, you wouldn't know until the next day.
That's why you do your e-fax, because it's.
Which is why, out of
actually-
courtesy, you always want to send stuff to the other agents or the other parties' email address as well,
Mhm.
their personal fax numbers as well.
I always call them and tell them, and if
And
they
yeah.
don't answer, leave a message, hey, I just sent you a fax with
Call.
confirmation.
Text, and so the heads up that I sent you a notice is fine in phone or text. The notice has to be via email or fax, and preferably fax. Okay? The other side, remember, we want to put in all their information, all their contact information, same thing, fax numbers, phone numbers, email addresses, all of that in there. What about the seller's name? Should you put a seller's name in there?
No, you should let when you send it to you, you will put it in there when you're finalizing it, because you're not 100% sure who the seller actually is, even though you've done your research on the text stuff.
In the world of commercial, we always use the phrase owner of record. Now, I don't think you'd want to write that on this contract, but when we write letters of intent and that sort of thing, we always address them to the owner of record. And hopefully, that gets to where it goes. Some people put names in here and, because they can always scratch it out and write the right name or whatever if they need to. If you pull it up on the tax records and the tax records say that, and to the best of your knowledge, John Smith owns this property, and it comes back with Bobby Jones, that's kind of a red flag. You want to know, well, wait a minute. My records show that you don't own this house, right? We want to make sure that the right person is signing the right contract. And so that's where, yes, your due diligence kind of plays into the, I don't think there's anything wrong if you've done your due diligence, as you said, to write their name on there and then use that as if that's totally wrong. Can you explain to me, listing agent, why everything that I pull shows that Bobby Jones doesn't own this property, but yet he's who's signing this? Can you explain to me why he's the one signing this? Because that's a legitimate question, and they should be able to legitimately answer that.
Yeah, because it always gets tricky with husband-wife thing, because sometimes you'll see like the husband's name is listed, but not the wife's name.
But again, whatever you see is what, in theory, should be correct, unless it was just done like yesterday and not recorded.
So you
Okay,
should
in the
put the
last 30
seller's
days.
name.
I think it's good practice to put the seller's name if you've done the research, because that's part of, it gives you some certainty that, okay, so according to what I've been able to find, John Smith owns this property. If John Smith signs it, then I feel relatively comfortable. If I think that John Smith owns it and Bobby signs it, wait, what? So that's my opinion.
So you're
When
about to run
getting
out of time.
signatures, even though we're doing e-signatures, do you at some point require a copy of the driver's license in order to verify the signature and the identity of the
We as a
signatory?
standard practice do not. Because the reality is at the end of the day, this is not a closing, it's a contract, and at the closing, the attorney's gonna do that.
They take everything.
But I'm thinking in
But
terms
yes,
of-
from a protecting your client standpoint, and that's something we can talk about. And so at some point, let's talk about the e-sign thing, and kind of how that process goes. Well, let's do it real quick. So
click your thing.
the e-sign thing, the reality is that if you do the e-sign, and this is not the e-sign class, but just from a methodology, you should not require, in the e-sign, you can of course add all parties, correct? You could add the seller, you could add the listing agent, you could add everybody. So if you have done the verbal negotiation and you know, hey, we've all reached an agreement, here it is typed up, give me your information and I'll go ahead and just loop everybody together in one transaction. Can you do that?
Yes.
Absolutely, you can do that. But generally speaking, if you represent the buyer and you're making an offer to the seller, you and your client are going to sign it. And if you remember back to the pen and paper days, after we sign it, we don't then give it to the listing agent and say, here, sign this, and then you can see it. We say, here's our offer. And so you don't want to loop the other agent in to sign the document. You want to deliver it to them with your party signatures on it. That is another common mistake with e-signatures. The other thing with e-signatures, make sure you include the certificates of authenticity with your contract packages, because that's what proves who signed it when. And that's the only identity checking system we have. And in reality, if you know that the husband-wife buyers, one's in China and one's in New Hampshire, and you look at the e-sign certification and the IP address is the same for the husband and the wife, what happened?
The husband signed for both.
One of them
Or
forged for the other one.
Or the wife
And
signed
they would
for
have
both.
to have a, what is it, attorney,
A power of
power of
attorney.
attorney to do that.
But
Otherwise you can't.
they wouldn't have signed the other person's name without writing as power of attorney or as attorney in fact for the other party. So that's where I think e-signatures are actually more valid than a lot, even wet signatures, because we as real estate agents, it's not common practice to ensure that the parties are all there. If we fax some or email something, they sign it and fax it back to us, we don't know who was there. We have no way of knowing who did what where.
What is a certificate of authenticity?
In the e-sign package, it comes, in the e-sign package, it comes as a part of one of the documents at the end of the package. And it'll if you download all documents, it'll come with it.
Okay.
Just remember to keep it with it as you send it around or turn it in.
And when you can go into e-sign history, Don,
And also print it.
and it'll show everything that's been signed, and that's on that list.
Okay.
And we'll probably do an e-sign class as part of this once we understand the contract portion.
I know some agents prefer not to use e-sign because it's quicker. For them, if they write up the contract, print it out, and they meet with their clients, everybody signs one at a time. Because sometimes when you send it through e-sign, I don't know what it is. It takes them forever to sign before you can actually then deliver it to the cooperating.
And that works great if they're here.
Yeah.
But the e-fax,
here's the reality.
e-sign
If they're
works.
here in this room and you have the contract pulled up on here, you can throw it into e-sign instead of printing it and have everybody sign it right here at the table while we're all sitting
and
together.
then hit send.
And then off it'll go.
I like e-sign.
Okay. The beauty of e-sign is that there's no scanning, there's no faxing, it's clean copy.
Paperless.
Paperless.
Oh my goodness.
All right. On that note, we're going to end a little long today, but I thought it was a good one. And next time we'll talk about the exhibits and things, so that'll be not next week though, right?
No.
No.
Sales meeting is the second.